Morning.
How you ready for us to kick off? All right, excellent. Well, good morning, everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Transport Security Amendment, Security of Australia's Transport Sector Bill 2024. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, you are protected by parliamentary privilege unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present that as Chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. In accordance with the committee's resolutions of the 7th of September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. The hearing today is being conducted with some members of the committee and witnesses appearing by video conference. Members and witnesses participating remotely are reminded to mute your microphones when not speaking. On that note, I'd like to now welcome representatives from the Australian Airports Association to give evidence today. For the Hansard record, could you please state your full names and the capacity in which you appear before today's committee?
Morning. Hi, Simon Westaway. I'm the CEO of the Australian Airports Association.
Morning. Sanjeev Sathaya. I'm the Senior Manager of Regulatory Affairs with the Australian Airports Association.
Thank you for that. Although the committee does not require you to give evidence on the oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in the evidence today. And if any questions are taken on notice, written answers will be required within a very short time frame. I'd now like to invite you to make a very brief opening statement, if you have one, before we go to questions.
Yes, we do. Thank you. Good
Thank you.
Thank you for this opportunity to appear today. The AAA represents over 340 airports across Australia. Now, this includes our major international hubs, regional and small aerodromes, and we also have 150 plus corporate members which support aviation nationwide. Our members are essential in connecting communities, facilitating trade and tourism, and supporting livelihoods. Today, 40% of Australians annually interface with a local airport, which we think is an important point. The AAA supports strength in our aviation security. However, we have genuine concerns about the Transport Security Amendment Bill 2024, which remain unaddressed, and we detail this in our considered submission. The AAA notes the inadequate consultation process by the Cyber and Infrastructure Security Centre, or CISC. Whilst appreciating our pre-election cycle that we are now all feeling like we're in, only 2 formal consultation phases with industry have actually occurred. The first allowed for minor feedback and legitimate concerns were overlooked. The second, a first-pass impact analysis, was a rushed process. Just a week for stakeholder response before the bill came before Parliament. A significant issue remains regulatory duplication caused by CISC's proposed all-hazards security framework. Contrary to CISC's claims, comparable international frameworks do not adopt such a model for aviation security. Examples that the CISC used in their submission from the UK, the USA and the EU touch on natural hazards in passing or are focused on critical infrastructure, but not aviation security. Australian airports already manage natural hazards under the Civil Aviation Safety Authority, CAS's Manual of Standards, which is MOS Part 139. These require aerodrome emergency management plans aligned with the International Civil Aviation Organisations, ICAO's Annex 14. Meanwhile, ICAO's Annex 17 governs aviation security and does not integrate natural hazards. This is a further example of unnecessary regulatory duplication, a disappointing constant across Australian aviation today. Compliance costs are a major concern for us. By the CISC's own estimates, implementation costs could cost our sector nearly $1 billion over the next decade. This is an additional expense for airports across Australia, particularly for our small regional airports, who will find it very difficult to absorb these costs. In 23-24, our major airports had over 97 million passenger throughputs, while our regional and rural airports had a little over 18 million in throughput passenger movements per annum. These costs will inevitably be passed on to the flying public, further increasing travel expenses, and in a disproportionate way will impact regional and rural aviation harder. Finally, while security is paramount, pushing legislation without due consideration is problematic and we believe is actually bad public policy. The AAA recommends a minimum 24-month compliance timeline rather than the proposed 1 year. This is to ensure effective implementation without the unintended consequences. In conclusion, the AAA urges the committee to refine, I should say, this bill to eliminate regulatory duplication, ensure a proportionate risk-based approach and mitigate the cost burdens. Thank you.
All right. Thank you very much for that. Are you happy to table that opening statement for us?
Absolutely.
Yeah, okay. Well, I'm going to hand the call over to the Deputy Chair to kick off with questions.
Thanks very much, Chair. Good morning, gentlemen, and thank you for your appearance today. That's a pretty damning assessment of particularly in relation to the consultation performed by government in relation to this bill. I want to, as a proud regional member, and I note, there are other members of this committee that are also regional members, but I have a terrific local airport in my electorate, Sunshine Coast Airport. Yeah. And I want to, without being too parochial, but it is perhaps a good example of the discrepancy between large airports and their capacity to be able to deal with the sort of imposts that are brought upon them by these sorts of regulatory changes, and smaller airports like Sunshine Coast Airport. Do you want to speak to how smaller regional airports are going to deal with these sorts of imposts should they be introduced?
Yeah, thank you. I'll take that. My learned colleague Sanjeev can also provide some add-ins as we go forward. Look, we've got a real complexity in this country in our airport sector, in our aviation sector. So around 200 of our airports across the country are owned, managed and run by local government, local councils. At least 60% of those run at a loss, and many of those run at a significant loss. Now that's an issue for another day, but if you've got to sort of think about that in that context. So for our major airport gateways, Sydney, Melbourne, Brisbane, Perth, Canberra and the like, they operate at a different business model, but of course they're dealing with passenger throughputs 10, 15, 20, probably 50 times the type of flows that you would. Now, in some ways, Sunshine Coast Airport probably sits outside that. The passenger volumes there and are moving towards 3 million passenger movements a year, and it's one of the fastest growing airports coming out of the pandemic. So they're in a different space, but nonetheless, the issues around increasing costs still impact an airport like Sunshine Coast as much as they would obviously smaller regional airfields.
Do you think that smaller regional airports, particularly regional airports, are aware of the security risks that are being faced and that are trying to be addressed by this legislation?
I believe they do. The issue for them ultimately is cost, but it's not just cost per se. It's regulatory overlap. It's the increasing regulatory burden, and when you have duplication, and this is perhaps I'll get Sanjeev to say something here. When you get duplication, that's really becomes a bit of the oxymoron in this whole thing. We absolutely get the importance of security. Completely. I mean, safety security is the number one priority, not just for the operations in and out of airfields, but also the people engaged around that. I mean, it's a guarantee, has to occur. But when you've got duplication, and sadly this bill is pushing duplication either deliberately or opportunistically or inadvertently, this is what we're facing, and that's why we're saying that we need a bit more time here, and also we need some better consultation, and let's work it through. No one's saying there are not significant security risks that our nation's facing, perhaps facing inside our own borders, but there'll be a burden placed particularly on the smaller airfields, both regional and rural airfields, that they won't be able to meet. And the owners of those airfields, local government in many cases, will have to be making some decisions around how they seek to meet that. So
You've spoken a lot about that duplication. Is there something that perhaps you're not missing, that the duplication you're concerned about is not real duplication? There might be a bit of overlap, but that the current laws may not necessarily be meeting all of the contingencies that might arise. What is the rationale of this legislation, and why is it so duplicative, duplicitous?
Yeah, sure. I'll answer that question. The challenge here is that they're trying to. I think the bill's trying to bring together the various responses or considered responses the government needs to take in response to the national, security risk that faces the aviation sector and other sectors. However, despite the fact that the consultation process has shown that there's been, we've raised duplication concerns, not just us but others. It's been acknowledged as well that duplication has been acknowledged by the department. If you look at the first impact analysis, it actually highlights those concerns. It shows the proposed position, the fact that stakeholders were concerned about this, but then that has effectively been ignored, and the position will remain the same, and we'll sort this out later kind of approach. And that of course raises concerns because we can see the problems up front in the bill, and if there's problems up front in the bill, well, what does that mean for the regulations? So we'd rather see the bill, correct and refined and targeted in its in what it's aiming to achieve, rather than obvious duplication. For example, CASA already oversees natural hazards and the way that they're regulated and managed at airports in Part 139 MOS that was mentioned earlier. And so government already has assurance through CASA and its regulations that that airports are in fact aware of this this potential threat and are mitigating against it.
Is there anything in this legislation that addresses capacity building for smaller airports?
Not that we've seen so far. And one of the challenges that we're faced with here is that it's not apparently proportionate. We've got a one-size-fits-all solution, and that again has been raised in the consultation. There's no concessions made in what we've seen in the bill so far to regional airports, and that they're expected to comply with the same requirements as major airports, which is not the way in which we understand the government would like its regulatory agencies to approach regulation. So there's the document RMG 128, which is managed by the Department of Finance because it's all about efficiencies, and this regulation isn't proportionate. It's just, as I said, a one-size-fits-all solution that really won't fit smaller airports at all.
And perhaps just add one more point. So we'll talk a little bit about what these costs are, real costs. So just in terms of what is being proposed in the bill, so for vulnerability management services, right, the cost could be between $50,000 and $200,000 annually. An IT security audit, there's a bit of a delta here in the range of price between $3,000 up to around $50,000. We're not making these figures up; these are real figures, and we're talking about some of these airfields.
Where have you got these figures from?
From our own work and from our own members.
We're happy to take that on notice.
Yeah, we can take it on notice and provide more detail around that if you so wish, because these are the real world costs that we have to deal with from airfields that may only move 20, 25,000, 30,000 RPT passengers a year, or a critical airfield for air ambulance and things of that nature. So.
Pardon my ignorance, but is there a sliding scale of security that these airports need to address, or is it if you're an airport or an airfield, you've got to meet these requirements under this legislation, no matter how large or small?
That's correct, yeah. That is how it stands at present.
No matter how large or small?
Correct.
So does it also apply in relation to airports that would, or airfields that would just generally deal with general aviation?
Yes.
Yeah, it could.
Yeah, so where the security screening legislation does have thresholds, there are no apparent thresholds in this legislation.
So an airport or an airfield like in the member for Flinders, like Tyab Airport, for example, that just is general aviation, has no paying passengers, they would have to meet the same criteria as Sydney Airport.
I think that question is probably best directed to the department. To be fair, I wouldn't want to mislead the committee.
All right.
Airport, but we'll ask them later.
Yeah. Okay. You can come back to me if you have time, Chair.
Yep. All right. Swanson?
Thanks, Chair. And welcome. Thanks for coming along and being the proud representative of Newcastle Airport. I don't want to try and out-airport you, Chair, but we have a particularly wonderful and growing airport in Newcastle. Thanks for being with us today. I just want to preface the question with the idea of timeframes. In 2021, the former government commissioned an independent review. Now, to my knowledge, this bill backs in all of the recommendations from that independent review. So that's going back to 2021. So in terms of the consultative process, would you not agree that this has been, in the wind and been discussed and been spoken of in airport circles now for the best part of 4 years?
Sure, I'd say that's true. However, I wouldn't agree with the assertion that it backs in all of the Heartland Review's recommendations. For example, one key element in terms of the consultation was the concept of co-design, that this legislation would be developed with a co-design process, and that certainly was not the case.
And also the premise, I mean, Mr Westaway just spoke about it. We know that we are living in an increased time of threat, diverse threat, degraded security settings in some respects. So the threats are real and there. I mean, we heard from the Director General of ASIO last night that, the world is a rapidly changing place. So I think that that's also given some context around, the 12-month time frame rather than 2 years. Is that 2-year period fixed in your mind? I mean, are you at all flexible on that?
Yeah, of course, we're absolutely flexible on these sorts of things, and we would like to be, consulted and have that sort of concept discussed and considered. In terms of the threat environment, yes, we do understand, that the terrorism risk has increased, that the threat status is currently at probable, and but what I would say is that throughout all of this, airports have always taken their responsibilities and obligations around aviation security absolutely seriously and do whatever they can to comply, and that's their goal. However, I wouldn't say that there's anything in this bill that appears to be critical. It's not plugging any special gaps that already that might exist in the legislation. It could be perceived as a bill that might harden the position in relation to certain threats, things like introducing systems testing and so on. But it's not. There isn't anything that I would describe that's been critical that absolutely warrants being implemented within a 12-month time frame necessarily.
So in relation, I just want to draw your attention to cyber security, because that really is the area where we're seeing just an acceleration, if you like, of all sorts of attacks, and particularly technology. We've seen with some of the emerging technology with AI in recent months that this is really something that we must take seriously. So I'd just like your thoughts around that. Given the tempo must increase, can you talk to me about the cyber threats that all companies face, but airports particularly face vulnerabilities, and we've actually seen that play out.
Yeah, again, airports are all right across cybersecurity. It's something that, again, airports take very seriously, and they already have mitigations in place for it. And I'll point to the fact that there is the SOCI Act that's in place, and the airports do already have reporting obligations on cybersecurity. I see the bill or the department sort of notes that there has been an increase in cybersecurity attacks on the transport sector. as its justification for effectively duplicating the SOCI regulations. They've talked about mitigating those reporting responsibilities by having a single portal through which the airports would provide their compliance reports, noting that one would go to that while they would actually go to different sections within Home Affairs. What does that tell you, or what does that appear to tell me, is that Home Affairs is already covering off those particular requirements under the SOCI Act. We haven't been told that there are any differences between the reporting requirements for the two pieces of legislation. So one can only assume it's exactly the same information but being provided to two different areas of the same department.
But to go to your question around 12 months versus 24 months, it's a good question. And what we're saying is that gives us the ability as a sector to work more effectively towards that. I know you've talked about time, but we've got to do with the moment that we're facing now, and we believe that the 24-month is a really strong concession from us as a sector. You'll probably hear from other witnesses from other parts of the industry today. That extra year of time will allow us to be able to better prepare towards what the intentions of this bill are trying to achieve if it becomes law. So we're trying to be practical, but we've got to be realistic. I think that's what we're saying. We have to be realistic, and there is duplication in this bill. It's a criticism we'll continue to call out no matter who is running the country, that there's an increased approach towards duplication as a way of addressing issues in terms of the regulatory and legislative framework that doesn't necessarily create better outcomes.
Thanks. Thanks, Chair.
Thanks for that, Ms Swanson. Now, Ms Mackenzie.
Just a quick one. Based on your evidence today and what I've read in the submissions, I can't quite work out if you'd prefer 2 years or to go back to the drawing board.
Well, I don't know that we need to go back to the drawing board per se, but I think our concerns certainly need to be addressed in this bill. And if they can't be because the horse is bolted, well, the regulations really do need to ensure that they do address those concerns.
And if it were to be going back to the drawing board, would you suggest a kind of collaborative co-design process? Because that's what I'm hearing. Including your smaller members, because they're the ones which will...
I think co-design's critical. I think you'll hear from other witnesses today who'll talk, and from the airline side will talk about the importance of co-design. I think that's actually imperative.
And has that been the model, to your knowledge, elsewhere? I don't suppose there'd be many jurisdictions like ours, actually, now I think about it.
It's definitely becoming what one would consider best practice in government and regulation just generally, to help ensure that the legislation that's ultimately implemented is fit for purpose.
And the opportunity cost, so if this goes through in its current state, how much time are your members spending trying to get their brain around this rather than just running an airport?
Again, I mean, if you look at regional airports, they're already dealing with those that have met the thresholds for screening requirements, for example. That's already a big headache for them because it increases the cost of operations. 60% of regional airports are already operating at a loss. They've got to hire staff. Ongoing operational costs can be quite considerable, up to $500,000. And then you look at the cost impacts and implications of this legislation. If it were to apply to them, which it appears to, then it starts to become really problematic. A longer time frame would also help airports spread the costs of implementing the legislation.
It improves their planning. I think they've just got an ability to plan and then to implement. And the changes in security were necessary, but obviously that's a significant impost, and it's been a big change for aviation, particularly at our regional and rural ports.
Thank you.
Chair, can I just ask one question?
Sure.
Arguably, an analogous country in this space would be Canada. Large expanses, long distances between airports, and many small airports, regional airports. What's a country like Canada doing in relation to this issue?
Well, you'd have to look at ICAO Annex 17, as being the guiding light for what airports are expected to be doing around the globe. And one thing that I can tell you that they're not doing is applying a all hazards approach, a security approach to security, which is one of the key pillars of this particular bill. it just doesn't fit, especially the natural inclusion of natural hazards in a security framework. Annex 17 doesn't mention natural hazards at all. So why are we incorporating natural hazards in our security response? That's already covered off by people that are experts in emergency management, and airports already have aerodrome emergency management plans that have those responses in place for those particular threats.
All right, thanks.
Thanks, Deputy Chair. Okay. Well, thank you very much for your attendance today. You'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections if any need to be made. If you've taken any questions on notice, the Secretary will also be in contact with you about providing a response in a timely manner. So thank you very much, gentlemen.
Sure.
Thank you.
We'll now get ready for our next witnesses. We'll have a round table of airline operators. We'll just suspend very briefly and get our next witnesses ready. Thank you. All right, good morning everyone. I'd now like to welcome representatives of Airlines for Australia and New Zealand, Qantas and Virgin Australia to give evidence at this public hearing. For the Hansard record, could I ask that you all state your full names and the capacity in which you appear before today's committee? We'll do it one at a time. We'll probably start from my right and then we'll work our way down.
Good morning. Stuart Lawson, Head of Group Security for Virgin Australia.
Stephen Beckett, General Manager of Government and Industry Affairs at Virgin Australia.
Emma Wilson, CEO of Airlines for Australia and New Zealand.
Good morning, Luke Brahma, Qantas Group Chief Security Officer.
Good morning, Trevor Jones, Head of Security Governance for Qantas.
Good. Oh, sorry, just check. Thank you for that. Now, although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. Given false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Given the short time frame, I just ask that everyone try and provide answers as succinctly as possible, and also if anything is taken on notice, we'll also provide you with an opportunity to provide a response in a timely manner. Now, I want to ask, do any of you have an opening statement you'd like to make this morning?
I do, Chair.
Thanks, Emma. Off you go.
Thank you. The airline industry in Australia, represented here today by AFA ANZ, Qantas Group and Virgin Australia, appreciates the opportunity to appear before the committee to discuss the Transport Security Amendment Bill. As the committee may be aware, AFA ANZ is an industry group representing airlines based in Australia and New Zealand, including international, domestic, regional, full-service and low-cost carriers. Established in 2017, AFA ANZ's members include Qantas, Virgin Australia, Regional Express, Jetstar and Air New Zealand. I'm fortunate to be joined today by experts in security from our members in Qantas Group and Virgin Australia. All airlines in Australia are supportive of measures to enhance aviation security that are proportionate to risk. We recognise that the aviation security environment is constantly evolving and as such requires the continued development and refinement of proportionate, practical and timely security measures, including measures to address a wider range of threats than those reflected in current legislation. Airlines in Australia have a long history of working with government and the aviation security regulator to ensure that any security measure put in place is fit for purpose and achieved an enhanced security outcome. We have worked and will continue to work collaboratively with the Department of Home Affairs by participating in industry forums, working groups and trials. We support Home Affairs' intent to reform the Aviation Transport Security Act and the Aviation Transport Security Regulations. However, A for ANZ, our member airlines and the industry more broadly do have concerns regarding the overall approach to reform, the potential impact of the proposed reforms, the ongoing uncertainty regarding the duplication of existing security and safety obligations, and Home Affairs' engagement and consultation with industry. The independent review into Australia's aviation and maritime security settings, also known as the Heartland Review, noted that there is broad agreement within industry that a window of opportunity exists for change, as government and industry have worked to reset operations following the disruptions of COVID-19. Aviation industry participants have made detailed and comprehensive submissions to both the Heartland Review and the initial consultation on these proposed reforms in June 2024. However, many key concerns and suggestions from these submissions have not been reflected in the reform process, this bill, or the associated impact analysis. While we do appreciate that the department has made some amendments to the reforms as a result of feedback from industry, we believe this selective approach to reform represents a missed opportunity for comprehensive and holistic reform of aviation security legislation in Australia. Furthermore, while we appreciate that Home Affairs were working to progress the reforms to the Act within a limited period, we remain concerned that in allowing industry only 5.5 business days to provide feedback on the first pass impact analysis, industry's opportunity to fully engage with the final version of the reforms and the analysis of the anticipated impact has been severely limited. And we're concerned that the impact analysis may not reflect the true cost of delivering these reforms. The Heartland Review noted that Home Affairs clearly values the principle and strategy of co-design. Unfortunately, this hasn't been reflected in industry's experience of the consultation on these proposed reforms. However, we would welcome the opportunity to participate in a genuine process of co-design with the department to revise this proposed legislation and achieve more holistic and substantive reform. We welcome the opportunity to further discuss these concerns today and the implications of the proposed bill with the committee. Thank you.
Thanks a lot for that. You're happy to table that opening statement for us? Absolutely. Excellent, thank you. All right, I'm going to hand the call over to the Deputy Chair.
Thanks, Chair. You've talked a bit about duplication. Can you give us some examples of where you see the main issues are in relation to duplication, please?
Absolutely. So I did note in my opening statement that I will defer to my expert colleagues from Qantas and Virgin Group, but I would note that our key concerns regarding duplication relate to Measure 2, the implementation of all hazard security obligations. But I will defer to Luke and Stu and Trevor.
If I may, Chair.
Sure, let's go in that order.
I think firstly, and as AAA alluded to, the CASA all hazards, natural hazards piece, we think is a clear duplication. For us, the concern in the future is what will be the duplication when the regulations, which we have no clear guidance on yet, will emerge with the future promulgation of those regulations. And also the potential duplication against SOCI and SONS, ATSB and CASA regulations at large. And whether that gap analysis or overlap analysis, if you like, of all that regulation has been properly conducted to avoid the duplication that is present or may occur. So we think there's
Can I just question you on that? Is it a matter of the concerns you have in relation to duplication? From what I just heard you say, that there's a concern around what the regulations might hold because you don't know what the regulations are going to contain. But it's sort of like it sounds like a preemptive concern around duplication. You don't know what you're going to get rather than you know that, well, the law currently around security of critical infrastructure says this, and this bill or regulation is in addition to that, therefore it's duplicative. Is it a preemptive concern?
It is a combination of those two elements. So it is existing duplication and the concern or the preemptive thought of what will come.
So are you jumping at shadows?
No, it ties back to the consultation and co-design principle. If we talk about consultation, and it's all relative, in a deep consultation with full collaboration and a co-design, we would avoid these potentials before they occur. So we believe that that process, whilst there was many opportunities for consultation, but how much of the feedback through that consultation process was taken on board and inserted into the draft bill.
The answer to that question by your evidence, Emma, is that there's been very little actually put into the draft bill from that consultation process. Am I reading that correctly?
That would be correct, Deputy Chair. I think one of the key concerns exists for us as well is that without seeing the regulations, and I appreciate that that's a process to be worked through with the department, without having that detail about how those potential duplications will be dealt with, there is a reluctance to greenlight or fully support the bill as written.
So is the department saying, trust us, we'll sort out the regulations later, or like why are those regulations not on the table, or at least draft regulations on the table for you to examine?
That may be a question to direct to the department, Deputy Chair, but we understand that once the passage of this bill happens from the department, that then we would start to work on the regulations. So I think that's where the hesitance is stemming from, without having all the information.
And there are two pieces that we see as a missed opportunity. A recommendation that the group and others, I think, agree with. There's a mechanism for alternative means of compliance within the Act as a machinery section for the regulations, and secondary management systems approach, which was option 20 or position 20 on the list of items to be considered for the bill, which were excluded. We're now down to the 15 items. So management system design, similar to the CASA approach, is what industry feels is the best approach moving forward. That is something that in our view should have been considered and incorporated within the Act. In the spirit of the early conversations around the Heartland Review of a wholesale reform, look at it from a greenfields approach and reset the Act and the regulations that meet contemporary threat and risk, but also are agile and allow mechanisms for government to bring in additional measures or allow alternative measures for a carrier, excuse me, or an airport or a small airport to comply.
You heard the Airports Association talking about how the duplication in relation to all hazards. Does that apply or impact the all hazards issue impact upon the airlines as much as the airports, or how does it impact on you guys?
I might pass to Trevor on the all hazards approach.
Yes, it does. In the same way that airports are regulated by CASA, so is the airline regulated by CASA. The other issue that we have is we deal with a number of regulators overseas, and we don't have any experience to draw on because none of them have an all hazards approach as it relates to security. Certainly in the safety space they do, but certainly not in the security space. So it's not as though we can look at the British requirements to see how it works or doesn't work with what's being proposed, or the Americans or
Canadians.
Indeed, Transport Canada. We're working with Transport Canada as we speak on co-designing their transport security program regulations that they're bringing in. And we've been working with the British government as part of a committee of other airlines on their security management system approach, and that's been going for 3 years, and they're not prepared to rush anything through. They want to actually get it right first time, and we appreciate that approach, even though it does sometimes take a long time.
So are you saying that the approach that is foreshadowed in this legislation is not being adopted or undertaken anywhere else in the world?
Well, certainly not where we fly. We have no all hazards approach requirements for any security regulation overseas. It's all dealt with in the safety space.
It's all dealt with
In the safety part of the
safety.
company. Yeah.
Thanks, Deputy Chair. I just want to check. Did Virgin want to add anything? I'm sorry,
Thank
I'd
you.
just ask to see if you wanted to add anything there.
I'd just like to add that we support the overarching concept of the bill. We do, however, feel that the bill, as it currently stands, has not utilised the opportunity for the holistic review recommended by the Heartland Review, and it hasn't drawn from industry in the way that we would like for co-design, in the way that Qantas has spoken about today also. So for us, in terms of the all hazards approach, conceptually, we agree that it's necessary to amend the security legislation in that way, but it's the detail and the guidance material that would sit in the regulations that we haven't had the clarity on as yet, and it hasn't allowed us to assess the full impact.
Did you want to add anything there? Okay. Thank you for that. Ms Swanson.
Thanks, Chair. Just in relation to consultation on regulations, has there been any indication from the department as to, what sort of input stakeholders will have in relation to regulations? Because it seems to me that's, from what you're saying, the evidence you're giving today, it seems as though the overarching intent of the bill is solid. Please, if I'm paraphrasing you incorrectly, stop me. There is some concerning duplication, especially around the all hazards approach. But from what I'm hearing, it is the regulations where, I suppose that's the devil in the detail. So what has been the department's instruction or guidance to you on how those regulations will be drafted and what input you'll have into those? I think, is that a fair question and a way to move forward on this?
It certainly would have been better if we'd received the guidance material before the bill went through, so we could see the holistic approach. We understand that obviously the department has time constraints, as everybody else does, so we appreciate that. But in respect to the regs, they have told us that once the bill has been settled, then they will turn their attention to the regulation. They're aware of our submissions to the Heartland Review and certainly to this process. We don't know what the scope is yet. We don't know how broad they're going to pick up the Heartland Review and which bits they're going to take on board. But we're anticipating that if the bill gets passed, that sometime later this year they will turn their attention to the regulations, and as an industry then we'll be provided with position papers and start a consultation process in that regard. We would prefer it be, this is what we're thinking, what do you think? How's it going to work in practice? How's it going to be operationalised? Rather than giving us potentially a set of draft regs and saying, okay, this is potentially what it's going to be. Do you see any problems? We'd rather eliminate those before the draft regs are...
So this is vis-a-vis co-design
Absolutely.
methodology. Okay.
Because we're all in agreement around the strategic intent,
yes.
The threat, the risk. There's no question that safety and security comes first, and that's across the board for industry. It's just how we do it well. So how do we improve the legislation to support that, but with the flexibility that you need in a dynamic and ever-changing threat environment, but also a very dynamic and complex industry. And cargo is the example. We could talk for hours about cargo, but it's not necessary here.
No. Thanks, Chair. No, that's it. I'm happy.
Okay. Yeah, if you could. Ms Mackenzie? Yeah, let's get the people here in line.
So thinking about the observations you've made, but equally that your friends who run the airports, would you look at the existing ecosystem and say there is a particular part of it that's a burning platform, needs attention, it's the thing that keeps you awake at night? Just because if government were to go down the path you're describing of co-design, that's okay, it takes time. Equally, I'm mindful, the Chair can tell us when the election's going to be, and there'll obviously be a caretaker period, and somebody can get on with drafting...
Minister, but I'm not. So.
Drafting regs during that point, possibly, just a suggestion for the government. But I'm just saying, is there what do you expect when our friends from the department come forward and say, but this must be now because, and would you agree that there is a burning platform component somewhere in this ecosystem that can justify haste?
If I can make a headline comment around supply chain.
One that will create a headline or just a general observation? Yeah, okay.
Well,
Supply chain.
just announced the election date there for a minute.
And
but anyway.
I'll take your headline off you. Supply chain and third-party assurance and how that's regulated and conducted. And those parties that are unregulated or less regulated is where we see some of the greater risks.
Can I get you to expand on that answer, though? Just
which part of the supply chain? Yeah.
Don't assume that we have the same knowledge as you
Absolutely.
and your industry.
Catering, an introduction of catering and its product into the supply chain or into the airport and aviation environment. On the cargo side, supply chain, second, third and fourth parties that provide cargo and consolidate down the line. So how well are we regulating that and the risk and the threat that emerges there, which is currently under some special security directions at the present time as well. And in our view, the systems management approach caters for that. Whether you're a large entity with the team and you know the sort of horsepower that we have compared to a small airport, if the management system is fit for purpose, then you can regulate and you can manage those threats and vulnerabilities and risks. So we operate, in our view, a sophisticated risk management system that caters for all hazards, but under various departments and various AOCs and responding to various regulations. So it's very, very complex. We're trying to support government in coming up with innovative and efficient regulation that satisfies the threat and risk outcome, but also the regulatory compliance outcome. Ultimately, we're trying to partner with the regulator, which is sometimes a difficult discussion.
Perhaps I could just add, when we talk about duplication, we also mean duplication within the company. So we have a all hazards risk approach inside of Qantas, which is managed by various departments, be it flight operations or freight or airports. And what we don't want is to break that apart, to have a duplicated system just to satisfy the security element of the security regulations. What we want is to be able to use what we have, which is primarily focused towards CASA, to then also satisfy Home Affairs' requirements. So we don't want duplication within Qantas as opposed to the regulatory duplication that we also talk about.
Thank you. In regards to your question about if it should slow down, would there be any burning platforms? For Virgin Australia, we don't currently see that there would be. We see that we have our obligations under the SOCI Act that we're already performing. We've got a well-established transport security program that has cyber security elements in there, as well as our uplift program for cyber security overall. And we feel that when it comes to supply chain security and natural hazard security, we're well positioned to be able to respond to those. We've seen examples of that recently with the earthquake in Vanuatu and our ability to respond to that natural hazard and return services in there in a very short period.
Thank you.
All right. Can I just ask, just picking up from the SOCI Act, as you know, it already requires critical, cyber incident reporting for many sectors. How will aligning the transport sector and transport security with these requirements improve the overall outcomes? Because I think that's probably a very important part here about what this legislation is seeking to do.
For ourselves at an airline level, we don't see any enhancements through that reporting. I think, as we're already covered by the SOCI Act in that element, I think it would need to maybe refer back to the Airports Association and to the wider concept of how the non-designated airports may be implicated by the changes.
Yeah, and look, to be fair, I know you've got a much more strong interest in the airports, but even the more broader transport sector, aviation and maritime that we're looking at here today, but I think there are intents to improve the overall standing of our transport sector with respect to both aviation and maritime. Is that some acknowledgement from your end, or are you just here to focused on specifically with the airlines that you operate in and out of?
Well, for ourselves, our focus obviously on the airlines.
Yeah.
We always like to see uplift in aviation security across the airports and the whole sector. So anything that can enhance that. But I don't think I could speak on the airports on what would be enhanced by their reporting.
I'm not sure, Ms Wilson, if you wanted to add anything on that front about Sochi and about improving the overall standards within the transport security sector.
Thank you, Chair. I think I did mention it briefly in my opening statement that we're very supportive as an industry of any proportionate measures to enhance security which have a measurable outcome and that are proportionate to risk. And while we do note that there are threats that exist that are not covered in the current legislation, while we support the broader intent of this legislation and aligning with SOCI, we do have, our existing concerns, which we've covered today.
Yeah, because for me, the concern is even if there are elements within the sector that are fine, if you don't cover the whole sector, it will have an impact indirectly onto yourselves as well and the airports. So the other question I had also was that unlike other critical infrastructure sectors, transport security legislation hasn't, by and large, substantially changed since the early 2000s. And I just wanted to ask, how has this affected your ability to address the current threats? I might start with you, Ms Wilson.
I would defer to my colleagues at the airlines to answer.
Perfect.
Chair.
Virgin and then Qantas?
So
Virgin?
Yeah, for us, I think whilst the Act hasn't changed overall, and the regulations have been limited in their change, I think particularly in place of our transport security programs, we have the ability to conduct our ongoing risk assessments and look at the proportional risks that we're facing. We continue to change and amend those, and you'll see in our transport security program we have measures for heightened security elements as well. So should the threat change, there's proportional steps that we can take to address that. In our transport security program, as part of that, it's our holistic risk assessment that we do. The airlines generally and Virgin specifically take the all hazards approach to our risk management framework, as my Qantas colleagues spoke about earlier, and we make sure that our program is addressing them holistically and not just looking at the regulation, but looking at the whole framework in which we operate.
Thanks, Chair. Would you not agree, though, that the Act, the law does need to keep up with current settings? It hasn't been revised for a long time. So, and please, I'm saying this in a way that fully acknowledges what you've already told the committee today in relation to co-design and making it better. But there is a need, would you not agree, for the Act to be modernised and brought to a contemporaneous, position?
If I could add, I 100% support, and Virgin Australia supports, I think it's recommendation 5.2 from the Heartland Review, that there is the holistic review of the Act and regulations, and we support that, and we would love to see an opportunity for that holistic review of the Act.
And Ms Swanson, if I may pick up on that question, and also one of the points you raised previously about understanding that this legislation is looking to pick up wholesale the recommendations from the Heartland Review, I would probably observe that absolutely this legislation is part of an agenda to address the recommendations from the Heartland Review, but it is by no means a wholesale uplift. Phase 3 of the Heartland Review, which we responded to in May 2023, had 26 recommendations and 66 sub-recommendations. And as Stu has just advised, it did deal with more wholesale reform of the aviation sector and had specific recommendations about how industry would be included in that. We've yet to see action on that. And probably my other point would be, in May 2023, industry was consulted on an initial response to the Heartland Review from Home Affairs, which covered 5 broad areas of interest. It's of note that the 15 reforms which were provided initially to consult with in May 2024 bore almost no resemblance to that initial consultation in May 2023 and the reforms that were initially consulted on. So I think that's part of why you're hearing industry today talk about our dissatisfaction with the process as a whole. I think if we would have looked to undertake more holistic reform and convening, technical industry experts like Luke and Trevor and Stu and from our airport colleagues to work really closely with the department on co-design, we would have seen a significantly different outcome. So I would probably note that, and that the 15 reforms that are currently being progressed as part of this legislation, while measures 1 and 2 are absolutely substantive and deal with cyber risk and all hazards, a lot of the others are really not substantive and are more administrative in nature. So we'd be keen to see like more wholesale substantive reform, and would be very happy to participate in that process.
Thank you.
Yeah.
Sorry,
Chair, just to make a few comments. You've heard here that we're all in alignment on the principles, and safety comes first for all of us. There are a number of reforms being undertaken by the government, including the aviation white paper, which we commend. We think that is a process for modernising and improving competition in the sector. We've heard from our colleagues at the Airports Association that the duplication of many of these measures would lead to significant cost escalations for airports, particularly regional airports, and we know that ultimately ends up being paid for by the consumer. And in an industry, Emma gave me some figures earlier, since 2000, 20 airlines have failed in Australia. We've heard Bonza's former CEO say that airport charges were its single largest cost. For Virgin Australia, airport charges are our third largest cost. These cost flow-throughs impact people, particularly living in the regions. They mean that consumers are on very marginal routes at a time we're trying to improve domestic competition. We have to keep an eye on both the aviation reforms and those other things like what we're talking about today, and how they feed into each other, because aviation is in fact a critical service for Australians. It's not a nice to have. A country our size, we need aviation connections, we need domestic competition. And that's precisely why Virgin Australia carried 135,000 Rex passengers free of charge after they entered into administration. We need to keep those people connected. We need to keep the competition going. And it's great to see what's happening through the aviation white paper. We would just love this all joined up, and the consequences of duplication, whether it be on this side of the department or that side of the department, are brought together, because one part of government's trying to achieve one thing and a different part of the government's trying to achieve something else. The intention is all good, but together we think we can make it better.
Thank you very much. Deputy Chair, you got one question?
Yeah, thanks, Mr. Beckett. That was really insightful. As a general question, and you may not be able to answer this question, and I'll certainly ask it of Home Affairs, but this process of reform has been going on for a number of years now. And it just seems to have perhaps unnecessarily been sped up just very, very recently. Can any of you throw some light on why this has been sped up all of a sudden? Why the consultation process, 5.5 days to respond? Like, what's the rush?
No, Deputy Chair, I can provide timeframes and industry perspective on that, but not the rationale for why this has happened.
And that's a cause of consternation on your part?
To an extent.
What does that mean, to an extent?
We have been disappointed with the process, as we've advised today, but we do stand ready to continue to work collaboratively with the department, given the opportunity.
Given appropriate timeframes to do so?
Yes.
In that co-design process?
Yes.
Yeah, okay, thanks.
Okay, well, thank you very much to all our witnesses for providing evidence. We'll give you a copy of the transcript, an opportunity to make any corrections if there are any errors, and the Secretary will also be in contact if there were any questions that were taken on notice. Can I thank you all for making an appearance before today's committee. We are now just going to briefly suspend and get ready for our next witnesses to do with Ports Operations Roundtable.
Thank you.
Thanks, everyone. All right. Welcome back, everyone. I'd now like to welcome representatives of Ports Australia and DB World to give evidence at today's hearing. Good morning, everyone. Hopefully you can hear me okay. I think some nodding. Yep, perfect. Excellent. All right. Now, for the Hansard record, could I just ask that you all state your full name and the capacity in which you appear today? And I'll start off with Blake, if I could.
Blake Tierney, I'm the Head of Corporate Affairs for DP World Oceania.
Thank you, Stenny. Who's next? I can't see the name.
Michael Gallagher and Suzanne.
Mike Gallagher. I'm the CEO of Ports Australia.
Hello, Michael.
Morning.
Suzanne Bosbury, Director of Industry Policy at Ports Australia.
G'day, Suzanne. And is it Louise?
Louise Riderman, Director for Health, Safety, Security and Environment for Oceania, DP World.
Excellent. Good morning, everyone. As you would have heard earlier, although the committee does not require to give evidence, under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. Given false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, I just wanted to invite you to make a brief opening statement. Do any of you have an opening statement you'd like to make for the committee this morning?
Not at this stage.
No?
Not at this stage, no.
Okay, excellent. Well, on that note, I'm going to hand the call over to the Deputy Chair to kick off with questions.
Thanks, Chair. My understanding is that there's some concerns around the definition of a port in the legislation or the draft legislation. The expanded definition of port and security regulated port now includes infrastructure, operations and assets outside current port facility boundaries. Would anyone like to expand on what the concerns are in relation to that?
Yeah, look, I think it's important, if I might kick off on this, Mike Gallagher, it's important to understand this has been an issue for a number of years, a concern that the industry has had as we as an industry and government have together travelled on this cyber journey, primarily because under existing legislation there are responsibilities to port entities that quite simply they've got no ability to be in a position to report to government on. If I can give you a very simple example of a container port, a modern day container port is much like a shopping centre, a Westfield if you like, and the stevedores are the Woolworths, Coles and the Aldis. Westfield does not know what is happening within the internal operations of the Woolworths, the Coles and the Aldis. But under the current legislation, clearly the responsibility sets with Westfield. And there are other operational aspects within a port that aren't on land. They aren't covered by, therefore, a map. And these include operational responsibilities such as towage, such as lines responsibilities, even pilotage, all critical to a port. If one of them was to not be in a position to operate because of a cyber attack, then all you've got at that port is a block of land waiting for that critical resource to actually be reactivated again to actually be able to operate.
Can I just clarify? Can I just clarify something with you, Mr. Gallagher? You said under the current legislation. Do you mean under the draft legislation or the current legislation as it currently stands?
The current legislation.
Right.
Now, what we're hoping that we will be able to do through the passage of this legislation that we're currently looking at in the context of the committee, as well as the regulations, is greater delineation in regards to those port entities that make up a modern day maritime port as opposed to an airport. So there are no gaps, and that is our concern, and I think DP World would agree with me on this as right across the industry. We want to work with government on these reforms to ensure that there are no gaps, that we don't find out about them later. And we've identified this one earlier on. If this is something we can rectify by identifying the responsible agency within the port sector, that would be a huge step for us.
And do you think that the current, sorry, I'll stop using the word current. Do you think that the draft legislation addresses those issues or not?
Look, it most certainly recognises it. We've identified that in our written submission to the legislation. However, so much of this will be borne out in the regulations. I am pleased to say that we have had and have enjoyed a very good cooperative working relationship with Home Affairs over the passage of these and other pieces of legislation for some years. And they understand what we are talking about, and I remain confident that we'll be able to address those finally in the regulations if they are not fully identified and clarified in the passage of the legislation.
Well, they're not, are they?
Well, they're not. There's a recognition, but we need to make sure that they are identified and addressed in the regs.
And as a stakeholder, do you feel like do you believe that Home Affairs has consulted adequately with you and listening to your concerns? And if the answer is yes, well, where's the proof in the pudding?
Look, when I say yes, they continue to liaise with us, not just on this, but on a whole host of other areas we work with Home Affairs on. This area that I've just raised to start with in terms of that delineation between the entities in a port, that is something that has been kicking around in our discussions with Home Affairs for quite a number of years, and it really did require that opportunity to look at both the SOCI legislation and the METOSA legislation to ensure that they were rectified. We're confident in the conversations that we're now having with them that we are going in the right direction to identify in the regulations those respective port entities.
Before I go to the issue of duplication, I want to give DP World the opportunity to answer the same question in relation to the concerns around the definition of ports. Is that an issue for DP World?
Yeah, look, Deputy Chair, we firmly stand on the same principles of what Mr Gallagher has just reached out on and discussed. I think the biggest piece for us is just making sure that we've got that definition right on both a port and also that security regulated port. From a DP World perspective, we need to have an idea that our inland facilities, such as our container depot at Yennora, need to have the same security requirements of those that are at, say, Port Botany or the Port of Brisbane or the Port of Melbourne as well. So there does need to be an alignment in both the SOCI and the METOSA Act, because at the moment there is duplication, and when we don't want to see greater regulation added to already a highly regulated sector. We want a sensible approach to what the legislation needs to say. And from a consultation phase, the department has engaged thoroughly with us in regards to this bill, but there is a bit of a misalignment of making sure that us as industry experts are actually bringing the department on the ground to actually see the mechanics of how our operations run, so that they can actually develop bills or legislation that is actually going to better the sector as opposed to adding further regulation to the sector as a whole.
That's a good segue into the issue of duplication. You will have heard, or you may have heard, previous witnesses talking about duplication in the aviation sector. Does that same issue relate to what you're talking about here in the maritime sector? Is this bill duplicating unnecessarily current provisions in other legislation?
So look, from a DP World perspective, we see it as we've got two separate bills, right? We've got one that says one thing, and then we've got another new draft bill that says another, where there is duplication. Now, under the current government's view of wanting to deregulate certain sectors, there is this duplication and also additional auditing obligations that we will be under, which will have extensive costs to our business. Now, to date, we haven't done that cost analysis because we want to see that higher level of engagement from the department to actually understand what the initial costs will be. But on a first basis, if I look at the amount of security that we have to have around our ports and terminals and also our inland terminals, it's subsequent of around $300,000 plus just for the current sites. And that's just an estimate of what we've done on a tabletop level of investment. So We're still trying to work out what the cost will be, but you can't have two separate bills, one telling us one thing, another bill telling us other, where there's duplication, where you've got multiple levels of having to basically inform the department on things that could impact the port. So a clear example is if we have a lightning storm at our Port Botany facility in Sydney, we have to shut down our operations for 30 minutes. Now, we could have 100 lightning strikes on that day. Under the current draft, it says that we need to report the reasonable impact to our port facilities, but how many lightning strikes does it take before you actually have to stop informing the department of these kinds of things? So you can see just from that example there of the impact that it can have to the national supply chain. Now, most people will know the supply chain is fragile as it is, but if we added additional regulation to what we already have, it's actually just going to have an impact on the greater supply chain further down the line.
If I can just add to...
Yes, Mr Gallagher.
Blake's contribution, another example of duplication for us is in section 171 of the proposed legislation, which has, in the event of a cyber attack or attempted cyber attack, ports and port entities reporting to both Home Affairs Secretary as well as the Australian Signals Directorate. So we're having to report to two entities. Our recommendation to government is that you create a single door for industry. There's a lot of talk about single window in the ports and the maritime supply chain area. We believe there should be a single door that we only have to report it once to that respective agency. And that agency would then disseminate it to the appropriate bodies in government instead of the port or the port entity having to make a series of phone calls and reporting responsibilities through to various entities within government. A duplication that we think is unnecessary, and again, a potential for a weakness in the dissemination of information that could be rectified with the creation of a single door.
I want to just ask Mr Gallagher, are you of the same view that there's greater clarity required around whether off-site facilities, depots, container park substations would fall under the new definition?
Look, they don't fall directly under us. They fall under, as Blake would say, under their interests.
Their remit, yep.
But yes, there's listening to our industry, there is no doubt there needs to be some greater certainty in relation to those definitions.
All right. Is there a need for differentiation between industrial and recreational ports?
Well, that's one of the challenges that we have, is that there are no two ports alike. They are all different. And in regional areas in particular, there are very heavily utilised recreational areas in proximity to the ports. A lot of the port area is determined by the Maritime Security Plan, which identifies the port area. But of course, for many people in the public, they don't know that. There is no red tape that they cross when they're coming across in their private vehicle or private vessel. So it continues to be a challenge for us in regional areas. And many of these regional ports are already captured under the SOCI legislation as well. So it is a challenge for us.
What is the current definition of a port?
From our perspective, it's a commercial enterprise where ports are where goods are either imported or exported, if you were to use a common term. But if we were to talk about Port Stephens in New South Wales, then clearly, apart from fishing, there is no commercial enterprise taking place where commodities are shipped in and out of that port, either domestically or internationally.
Well, look at for example, something that I can relate to, and that's Mooloolaba. So Mooloolaba is a fishing port.
Yep.
That is, in fact, one of the largest eastern seaboard fishing ports in the country. Would that be captured under the current definition of a port, and would it be captured under the new one?
Not from our perspective. It wouldn't be captured under the definition of a port. Whether the government would view them from a regulatory perspective at a state level, because they're captured under environmental laws and there's other local laws that would apply to a commercial enterprise taking place in a marine environment. But from our perspective and under what I believe to be the current legislation, Mooloolaba, unfortunately for you, would not qualify as a port.
Do you think that there's sufficient clarity on that point as to what ports would be covered under the bill and what wouldn't?
We feel that there are. No one has raised with us amongst our membership concerns around that definitional aspect, and we'd be open to look at that for greater certainty if there was a concern being raised from outside, but we haven't had it raised with us.
Right. Is that something you could come back to us on? I don't know the answer to it, and it's not a loaded question. I just want to make sure that we are sort of cognisant of it.
Yeah. Absolutely. I mean, very happy to supply any information that the committee requires to better understand the port sector. We've recently released a state of trade report that will give you greater clarity around trade going in and out of our ports around the entire nation. And that may also assist you in terms of getting your head around the numbers. It's about $650 billion worth of trade. There's shipping movements, there's employment numbers, there's GSP, everything in the report. I'd recommend probably having a look at that to put things into perspective for members around the trade that we're talking about.
You can keep going a few more.
Can I take you to the mandatory privacy incident reporting issue of, so what's proposed is a 12-hour reporting requirement for significant cyber incidents. Is that operationally feasible or not?
It has not been raised with us as a real issue of concern. I'll hand over to Susan Fosbury from my team, who's spoken on some of the details to individual members. She might be able to put a perspective on that.
Yeah, we have had raised with us concerns in relation to the differences within the legislation with respect to reporting timeframes. In relation to some cybersecurity incidents, it would be important for them to be reported within a timely period. It's always going to be about the differences in timeframes and possible confusion with both entities and individuals with respect to it. So we've certainly called for, where consistency can be put in place, that we have that consistency.
Is that a matter that comes back down to the definition of what a significant impact is?
Yes.
So,
and particularly in relation to attempted cybersecurity attacks, that is going to be one of the biggest areas of challenge to our industry. And I would assume with airports as well, because there are so many attempted cybersecurity attacks each and every day within industry, not specifically ports, but within industry in general, that will be very challenging.
One of the recommendations that I think perhaps the committee could consider is that in the current maritime environment, we have a government-led consultative body called the Maritime Industry Security Consultative Forum, and it brings together all of the major players in the maritime sector to discuss the security environment, but from a land-based port planning perspective. We see a vulnerability in that in our ports, the maritime security personnel are not the people directly responsible for the response or the preventative work prior to an attack from a cybersecurity perspective. And I think it's worthwhile now for there being given consideration in the formation of a supply chain equivalent of the Maritime Security Consultative Forum that looks purely at cyber, but it's end-to-end. It actually includes not just the port sector, but those entities along the supply chain, because if you hit one, you can hit all. And if you take one out, you take the entire supply chain out. And I think given the heightened awareness and the heightened risk vector that we now see in this space, that government should consider the development and creation of a cyber forum that primarily focuses in on the supply chain to ensure that they have that ability to have that dialogue with them in the same way that they do with maritime security now.
Can I take you to the next issue of asset interference reporting? there's some concerns around the broad definition of assets, raising concerns about feasibility, particularly regarding external events. For example, protest activity, blocking port roads, telecommunications outages, etc. Is that an issue that you're tracking?
Most certainly. I might actually ask Suzanne to speak to that in a moment, because that continues to be a concern to us, as well as the involvement of state authorities and their legislative responsibility, particularly with regards to disruption or protests, or indeed breaches of the maritime security perimeter around the port environment.
And just to throw another one in there, you might also want to address the issue of the inclusion of international supply chain components, such as Chinese manufactured equipment.
Certainly. There's an expanded definition in the legislation in relation to unlawful interference and operational interference. There are specific carve-outs within the legislation, TOPSA legislation, in relation to lawful activity that involves protests and things like that. Obviously, state and territorial police forces respond to protests of individuals. In relation to the definitions for unlawful interference and operational interference, it is going to be very much about the regulations, about the interpretation of that, and the department keeping a watching brief in relation to where individuals or group of individuals are acting in ways that's not lawful protest. It is in relation to sabotaging the supply chain and the security of the supply chain. In relation to the legislation going down the supply chain with respect to having to do risk assessments and security assessments, it is a matter of concern to our members with respect to how far down the supply chain and just the level of sight that they have with respect to individuals within organisations that are supplying services or equipment to ports, and what sort of checks that you are practically able to do with respect to overseas organisations. And once you detect a problem, you've got contracts in place, and just how the practicalities of that are going to work. So there is a lot of things to work out in the background of just working through all the different processes, the what ifs, that, you know, having the some guidance in place from the department in relation to what sort of parts of the supply chain you need to be looking at, what sort of measures you need to take, and what to do when there are issues identified, and how we work together to respond to those things to come up with a collective approach that doesn't mean that everybody is going in different directions.
That guidance, though, hasn't been provided by the department because the regs haven't been provided to you?
Yeah, that's correct. So the department have said that it's going to take a 12-month process to work through all of that things with the legislation. We anticipate that there will be issues identified with the legislation throughout that process that we may need the department to come back to government to recommend modifications, clarifications within the legislation itself. But the regulations for us are going to be very, very important to get right. And we would anticipate that the department, as soon as the legislation is passed, if not beforehand, would sit down and have a process of consultation across industry to make sure that we are having a valuable conversation to get everything in place in time for people to be able to implement it from day one without any issues.
Thank you.
Thanks, Deputy Chair. Ms Swanson, you've got the call.
Thanks, Chair. How would you describe your interactions and the process with the department thus far in relation to this bill?
Well, I'll let maybe Blake kick off first, because he hasn't had a chance to give an individual terminal operator's perspective, and then I'll come back and give mine. It might be different from yours, Blake, I don't know.
Look, Ms Swanson, we have a very deep engagement with the department, especially on this bill. They're well aware of our concerns in regards to this. It's of obviously everyone's knowledge that DP World suffered a cyber incident in 2023 in November. And so we've been working closely with the department in regards to these reforms and have shared with them our thoughts and feelings. But from our basis, I would say that as part of this piece, there has been general consultation. It is, if I could give it a rating out of 10, I'd say it's about 8 out of 10 for us, but that's specifically us. That's because we're working with the department every day on a wide range of projects from our ports. So from us, it's pretty strong.
Thank you.
From our perspective, the majority of our members are state-owned ports, and they are familiar with working with departments. I can say from our perspective, we have been very pleased with the engagement we've had with the department, not only in regards to the journey in this bill. Okay, it's been a long time, and I recognise the Deputy Chair's comments. It's been a long journey. Yes, it has. But we want to get it right, and they recognised very early on the difficulties they had with the definitions that existed under pre-existing legislation. We like to think this is a very positive step towards us getting resolution and certainty around a number of these issues.
Thank you. And look, I suppose I just make another, it's a bit of a general observation, but obviously we're seeing an uptick in cyber attacks, cyber activity, and it's something that is a challenge for all access points, if you like, whether they be maritime ports, airports, all touch points and security points around the country. From your perspective, from a port's perspective, do you think that this bill will go far enough to assisting you to be able to, lock down your facilities?
Look, the reality is, of course, that this forever is going to be a continual journey. There's no end to this, as AI and highly technical expertise is invested into cyber attacks on countries not just like ours, but right around the world. Last week, I was involved in a late night discussion with representatives from right around the port sector globally. The number one issue is cyber. So we are not the only ones being hit. We're, in with just about everybody else. This is another step in that journey, and in another year or 2 years or 3 years, we'll be back looking at further evolutions and further ways that we can enhance this. That's why I make that plea. It's important to bring together a committee that will be a standing committee whereby government can, through confidentiality, deeds of confidentiality, impart information to those along the supply chain in terms of the intel they are getting from those agencies in the Australian cohort that are protecting us from these attacks, to ensure that they are being disseminated in a timely way, that we are ready, particularly based on what is happening globally. We are not the only ones being attacked. We should be able to learn from one another, learn what's happening globally, and be able to disseminate that quickly in a confidential way to ensure we have those systems in place. I think to do otherwise just leaves the door open to an opportunity for a fortuitous attack using AI, which is operating 24 hours, 7 days a week, to try to get through the firewalls to be successful.
Can I just pick up on another point there? Thanks, Mr. Gullar. I just want to pick up on one other point there. We know that the ASD are very willing and wanting to work with corporations and businesses across the country, because often you are that front line of attack, and it's very important that they do receive information from you, and we've seen some changes to reporting of cyber attacks. So I did note your comment about a window, I think was the phrase you used, a one window approach for the feedback of that information. But we have noted that ASD really, want to work closely with the private, with private enterprise and ports, and all of those outward-facing vulnerabilities.
We've met with the relevant government organisations and continue to do so. We bring together, we're very fortunate, we bring together within our structure those people who have technical responsibilities for those areas within the port environment. They can be the harbour masters, they can be the port cyber security personnel, the port security personnel. It's not uncommon for us, and in fact we will be having a presentation from one of those agencies to our port cyber security personnel very shortly. It is again about building those lines of communication, but ports are just merely one cog. We need to ensure that all of those on the supply chain are on the same wavelength.
Noted. Yeah, thank you. Thanks, Chair.
That's all right, thank you. Now, I don't know, Mr Gosling, if you're still on the line, if he had any questions. Otherwise, I think being none others.
I could keep going.
I think we're going to wrap up in about 5 minutes. So,
yep, I'm in your hands, Chair.
Yeah, I think Mr. All right, well, I'll hand the call back to you, and then we'll wrap up at 10:15.
Thanks, Chair. In relation to Section 10, capital C, in the business impact of authorised access, the legislation or the bill permits various government authorised activities that may disrupt operations. Is there any opportunity or recourse or cost recovery mechanism for business to be able to get compensation for that sort of action?
I don't believe there is, and it can be quite a difficult issue for our members. Many of our members will, in fact, quite often sit down with people involved in protests and agree with government, with New South Wales Police or with Victorian Police or any of our state law enforcement agencies to determine the times of the protest so it can act lawfully. What will happen then is there is disruption during that time, but we all accept that people are entitled to air their concerns, and we work with communities in that regard. What disrupts us greatly is when the permit expires at a given time, 3 o'clock in the afternoon, and then all of a sudden the people who want the media enter the water and therefore cause the disruption when we have a large vessel coming into port. The potential risk is just catastrophic because not only could we find ourselves in a situation where people are injured, but equally we could find ourselves where the vessel blocks the channel and therefore the economic impact is huge. Going back to your question, is there an ability? I haven't seen it yet, and it's something that I think the courts need to take into consideration when they look at these issues. People have been given lawful opportunity to express their views, but those who want to operate outside of that agreed timeframe, they should be looked upon very sternly.
So are you saying that there doesn't need to be some sort of recourse?
I don't know if you cover it under this legislation. That's the thing. I'm not sure it would be covered under this. It's probably something for a bigger discussion in terms of the way protesters and disruption is treated, particularly intentional disruption that's unlawful. But I don't know if it would necessarily be covered under this legislation in terms of putting compensatory aspects to it.
Okay, but it's
I like to think that we can recognise it.
It's a conversation you'd like to see had. Just finally, in relation to compliance statements in Division 6, there's a new requirement which mandates an annual statement of compliance for each maritime security plan. Is there any further clarification required on the implementation of timelines and whether existing MSPs require immediate updates?
Yeah, I think we've had reports from our members that they have gone to renew their maritime security plans and have had the timeframes changed for them going forward. So I think we had where they were going for 5 years and it was renewed for 3. The annual statements, we've sort of said that it's important that the department works with our members with respect to what they already have in place. they have a lot of business continuity plans, they have emergency response plans and everything. The annual compliance process and getting the board or the governing body to sign off on it will take some resourcing, it will take some costs, obviously, to do that. We haven't asked our members or sought from our members what that cost will be, because I think it's going to be very much based on their particular port and how they're already reporting to their board and how they're regulated. So a lot of the state government agencies obviously are reporting not only to their shareholder ministers, they're also reporting to their audit officers and all the other reporting things. So they already have in place that. We've asked that where possible, current forms, current plans, as I said, are included in the consideration that Home Affairs put around the renewal every 12 months of the plans. And we've also sort of raised some concerns in relation to the processes of, with respect to 174, I think is the section, 178 it might be, just in relation to show cause notices. So whether the Secretary under the legislation can just cancel a plan because it hasn't met the 12-month annual review process, and then it would have to go to the Administrative Appeals Tribunal rather than having a show cause notice, which is in other sections of the legislation. So we're just sort of saying that it should be consistency, it should be about sort of following some appropriate processes and allowing our members, particularly with ports, which is so important to the supply chain, to work to get it right and to comply rather than sort of taking harsh action straight off the bat.
The question, of course, is why? Why are we going down to 12 months? And given the amount of planning that would need to go into this, this would be like painting the Sydney Harbour Bridge. It would be constantly undergoing the process to get it ready, to get it before the board, make sure the board's happy with it, then get it to the government. Why are we going down to the 12 months? Where is the identified faults in the system that would warrant it going down to that way? And then, of course, if it then gets caught up in the bureaucracy, what then happens? Surely they're not going to say, well, the port can't operate until that maritime security plan is in place. No, it's going to be relying on the existing plan until whatever issues are identified that need to be thrashed out. It's probably something that I think we've got to look at ways in which we can not have such a regimented approach with regards to 12 months. But of course, I asked that question at the start. Why do we have to go to 12 months, given the plans don't really vary that much? And what will vary will be the cyber response, because that continues to evolve. But in terms of the actual maritime security plan, the port is the port.
All right. Thanks for that. Now, Ms Swanson has, I think, one question, then we're going to wrap up.
I think it comes in off the back of the point you've just made, Mr Gallagher. It occurs to me that we do face this rapidly changing cyber environment, and we haven't seen a change in the bill for 20 years. So I guess the point I'm asking you is, do you agree that we obviously do need to change? We do need to change the bill. We do need to have a more responsive architecture. I'm rapidly of the belief that I'm not quite sure how bills are going to fare in the modern world, whether they are going to be able to keep up with changes, and will it come down to regulations, will it come down to much more regular conversations. But I am just interested in, and perhaps Mr Teeney and Ms Radaman might want to comment on this, but how you've seen the threats and the security environments in ports change in the last 20 years. Give the committee some sense. We know that they have, but what are the changes that you've seen? And, this bill's not perfect, but it must go some way towards addressing some of those changes.
Do you want to kick off first, Blake, given your experience, DP's experience with that significant attack first, and then I can come in with an overall?
Yeah, of course. And look, I'll also get Louise to jump in on this one as well. I think to answer the question, companies now are facing multiple attacks a day from any cyber event, as many will know. I think our sector in particular, because obviously Australia is that trade nation, there is going to be consequences where there's going to be that push every single day of more and more threats. And we have to get ready to what that's going to look like. So we need to, as a sector, start to facilitate, legislation that is going to actually change on momentum. And so making sure that the legislation is changing to actually keep up with where cyber criminals are actually going to start implementing their work. Like we see it every day. We see the changes that are coming through, but businesses need to be prepared to have that investment on the table to make sure that they're actually being agile enough to face what the next wave of cyber criminals are going to be pushing through. And it will have an impact on the supply chain, but we have to be ready as a sector to actually prepare for that. And we've got to do it quickly, and we need to be agile as a sector to move as quickly as we can. And that's why the regs and the legislation needs to be kind of futuristic in a sense to make sure that we get there a little bit quicker. Louise, you'll probably add more to this than I.
Thanks, Blake. I agree. And Mike, to your earlier point as well, I think what's important is that there's a focus on working collaboratively, not only within the ports, but the entire transport network, but then also with government, making sure that we work collectively towards what the most efficient processes are, reducing duplication or not introducing additional duplication, so that all our efforts go into protecting our most valuable resources in this country. So I think the key for me there is around working together, looking at where we streamline things, how we better connect people and how we better communicate in this process. And whilst it is important to write that into legislation, not to duplicate it in legislation, that then makes those conversations harder to have. So really working together as an industry, but also government, to get that information through to each other much quicker and working collectively.
From our perspective, the question was around from looking at it in terms of the overall changes over the last 20 plus years. It's in many areas, both in terms of the investment in the infrastructure, even decarbonisation. Decarbonisation has seen port equipment steadily move away from old diesel-powered, independently operated machines to ones that are integrated using, state-of-the-art renewable technology, but integration into highly technical IT systems. These didn't exist 20 years ago. If they did, they were in their infancy. But now you don't necessarily have to hit the port to bring the port to a grinding halt. You could hit one key aspect of a supply, and it could be energy. It could well be taking out the pilots, technical systems insofar as bringing vessels into harbour. That integration is, of course, increase the risk. In increasing the risk, we have to look at ensuring that the government's response and industry's response is equally integrated and cooperative, working closely side by side. They can't operate in isolation anymore. They are all one in the same in relation to this. So this bill most certainly is a step in that direction, but as I alluded to earlier, it's not going to be the end of it, sadly. This parliament and state parliaments will be looking for future responses to emerging risks as the threat evolves. So too must our response. But this is significantly for us a recognition that there are some gaps and we can start to fix them.
All right, thanks a lot, everyone. And can I thank our panel today? Thanks for making time to appear before the committee. Very important evidence. And just want to say thank you to you and all your staff who do a fantastic job on our ports every single day.
Yeah, they do. Thank you.
All right, on that note, we're now going to suspend. The committee will be back here at 10:45 with the Department of Home Affairs. Thanks, everyone. G'day, new team here. Excellent. All right, welcome back, everyone. I'd now like to welcome representatives of the Department of Home Affairs to give evidence today at this public hearing. Now, for the Hansard record, could I ask that you all state your full names and the capacity in which you appear today?
Thank you, Chair. Sally Pfeiffer, First Assistant Secretary, Critical Infrastructure, Partnerships and Policy from the Department of Home Affairs.
It's quite a mouthful, that one, but thank you for that, Sally.
Christopher Fox, Assistant Secretary, Screening and Maritime Security Policy from the Department of Home Affairs.
Matthew Pedler, Assistant Secretary, Aviation Security Policy, Department of Home Affairs.
Jennifer Ellison, Director, Transport Security Reform.
Excellent. So now, Matthew, could I just ask you to move that book out of the way, just for more for Hansard? So, thank you. Thanks a lot. Okay. Now, thank you for also providing a copy of your opening statement. Did you want to read or add anything else to that? No, otherwise, we're happy to table that opening statement and go straight to questions. Yep.
That's fine.
Okay. And before I do that, I should just also remind everyone that that today's hearing, even though you are not required to give evidence under oath, you are advised that this is still a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a very serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'll now hand over the call to Deputy Chair to kick off with questions.
Thanks, Chair. Thank you for coming in this morning. To the Department's knowledge, what's the reason for the compressed time frame for this inquiry?
Thank you, Deputy Chair. The time frame, we've had an extensive time frame for discussions of the proposed way forward. We have been talking about the measures that we were looking to introduce, what we were looking to change in response to the Heartland Review.
Can we get a bit more volume, please?
Sorry, I'm a little quiet.
That's better.
I have never been accused of that before. So. We have had an extended period of consultation and engagement with the industry sectors that are impacted by the transport security reforms over a number of years, including from when the Heartland Review was initially finalised and then consultation from there. So there has been quite a period of time. In the sense of the more immediate time frames, there are requirements for us to meet certain deadlines to achieve the objectives of introduction, and we were able to meet those. But we built that on the basis of the extensive consultation that we had done with industry.
I don't know that answers my question, and you may not be able to answer it. I understand, but there is very much a compressed time frame for this inquiry. Also, there is a compressed time frame for stakeholders to be able to respond. I think the previous witnesses were talking about 5.5 days to respond to the bill. I appreciate there's been, I think it's fair to say, extensive consultation over a number of years, but 5.5 days is an inordinate short period. Would you not agree?
Senator...
No, I'm not a senator.
Sorry, Deputy Chair.
I work for a living.
I apologise. I do apologise. Deputy Chair.
Out of order there, Deputy Chair.
You're outnumbered.
Whilst there is a short period of time, the 17th to the 24th of October, that was the first pass impact analysis consultation process. There were consultation papers and the early assessment of the impact analysis were provided to approximately 3,000 individuals of industry stakeholders between the 22nd of May and the 11th of July. We conducted 2 town halls, 3 industry roundtables, plus 3 costing ones, 3 tables, roundtables that focus on the costing processes.
Yeah, I'm not being critical of the department's overall consultation. I mean, many of the stakeholders have come before the committee and have said that the consultation has been extensive. I suppose what concerns me greatly is the compressed time frame in which the stakeholders had an opportunity to provide feedback to the department, and what I'm particularly concerned about is the time frame in which this inquiry has been so compressed. What's the rush? Given that we've been dealing with this since 2021, and then all of a sudden, we need to deal with this matter by the 7th of March. What's the issue in relation to the 7th of March?
The timeline for this committee's consideration is actually not at the department's request or
okay, but I accept that, but can you shed any light on why there is such a compressed time frame for this inquiry to be able to report back to government?
Again, sir, Deputy Chair, I'm unable to comment on the timeframes for the committee's consideration.
Okay. Multiple submissions raised concerns regarding the regulatory impact and cost burden created by the bill. Has the department considered whether the regulatory impost could be pushed onto consumers? And what does your modelling suggest the additional cost to consumers will be?
I'll ask Ms Ellison to discuss, to provide evidence regarding the impact analysis and the cost to consumers. Of course, we are always very concerned about costs to the public, but our first priority is to consider the security of our transport security industries to make sure that they are, those security measures are effective and protect the Australian public. It is certainly a balancing act.
Yeah.
Ms Ellison, can you discuss the impact analysis?
Thank you, Sally. The impact analysis was conducted with industry. We only received 4 submissions from both maritime and aviation sectors that would assist us to analyse the costings. But in terms of passing it on to consumers, that's a matter for airports and airlines.
Would you mind just saying that again, that the cost to the public is a matter for the airports and airlines, but you're building a regulatory regime that is going to impact upon them, that they are going to have to pass those costs down to the public. What modelling has the department done to determine what those cost impacts will be?
We conducted an impact analysis last year with industry. So we drafted an early assessment impact analysis and provided that to industry with the consultation measures, and we gave them from the 22nd of May to the 11th of July to provide costing impacts to their entity. In response to that consultation, we received 4 submissions from both aviation and maritime sectors. Based on those 4 submissions, we were unable to form a comprehensive view, so we used costings from the SOCI Act, and from that we developed costings based off industry complying with the regulations, having a baseline of not having any mitigation measures for any of those all hazards. So if we were to work out what those costings were based on whether or not an entity was mature and had those obligations already mitigated, that would reduce the price, or the cost, sorry.
So the answer to my question is that there's been no outcome. You haven't come up with costs as to what this bill will do for costs for consumers. Am I right?
We've come up with what it will cost industry, and then...
How have you done that when the industry's been, I think it's fair to say, critical that you haven't provided the regulations? How do you, as the regulator, determine what cost impacts there will be when you haven't provided the details?
So, Deputy Chair, we do have information regarding the bill, and we have done some initial work and provided industry advice on how we intend, based on the bill as it currently stands, to work through the regulatory process. So we have provided information regarding the regulation without providing the draft regulations.
Well, they're all sitting before us saying, the devil's in the detail, we don't have the regs. I think that's a pretty fair complaint that they're making, isn't it? Why haven't we provided the regs to them?
As I was saying, Deputy Chair, we have provided information around our intention of how we will be preparing the regs, the framework that we'll be using, and have had initial discussions with industry regarding those regulations and the way that we propose to use them and to affect things like removal of duplication. We will continue to work with industry through that process. The impact analysis was based on and continues to be based on the information that we've been able to provide at this stage and extensive consultation with industry around the intent and the way forward that we're looking to take the regulatory framework.
Why haven't we provided copies of the draft regs? Is it because they just haven't been finalised, or what's the rationale?
We are preparing the regulatory framework as part of the discussion. However, we would like and have continued to engage with industry on a model where we evolve the regulations as we move forward based on the way that the bill will be amended. Sorry, the Act will be amended.
I get by the very nature of regulations that they are, and Ms Swanson made a very good point that legislation, particularly in this sector, has a real job in trying to keep up with the threat levels, and this committee knows that better than any committee. But it's also equally important, I think, when we're dealing with, particularly when we're talking about the cost impost of these changes, that the stakeholders are aware of what it is that what the regs are going to say. Now, I know you can't say what the regs are going to say in 12 months' time or 18 months' time or 2 or 5 years' time, but if you're asking them to come on board with you, and you've heard the phrase, co-designed process, there's varying levels of acceptance of to what extent the department has included these stakeholders in the co-design. Some, particularly in the airports and airlines, airports feel as though they have been less included in the co-design process than, say, what the ports were just a moment ago. But have you looked at, has the department looked at the disproportionate impact on regional airports as opposed to your large city airports?
Yes, Deputy Chair, we have considered that, and the reform package, the legislative package that we're putting forward, is actually scalable depending on, particularly I'm speaking of the aviation sector at the moment. So not all of the measures apply to all airports or to all airport industry participants. It's scaled on the basis of the tier of the airport. So as you would be aware, we currently have designated airports, Tier 1 airports, Tier 2 airports, depending on their complexity, the sectors that they might particularly be working in, size, those sorts of things, and the requirements, the regulatory requirements, will not be applied to all of the airports. So regional airports, and particularly small airports, will see little to no impact of these changes.
Where would the Sunshine Coast Airport, for example, fit into that paradigm?
You're trying to promote Sunshine.
I am always trying to promote the Sunshine Coast. Unashamedly, that's my job.
I must say the Sunshine Coast Airport is one of our particular favourites, and we do enjoy the Sunshine Coast. I'll ask Mr. Pedler. And Newcastle.
And Tyre.
Deputy Chair, I think Sunshine Coast, I believe, is a Tier 1 airport, if I recall correctly. I'll have to correct that one. But so there, in terms of the all hazard security obligations, the obligations would apply to Sunshine Coast Airport as they would to Newcastle Airport. So as Ms Pfeiffer said, we have 9 designated airports, 5 Tier 1 airports. I think it is 44 Tier 2 airports, all of which do screening, but to different standards. Then there are Tier 3 security regulated airports that don't do screening. There will be different graduations of the obligations that apply, but at then that larger end of town, designated and Tier 1s, then all of the obligations in the package will apply to those airports.
And have you done any modelling on what the cost impost will be for the various tiers?
I'll just turn to Ms Ellison and see if you have the cost study there.
From the 4 costing submissions that we received, one was from a regional airport, and they advised that due to the smaller nature of their airport, the resources that they employ, it might cost 7.5% of what a designated airport might cost in some instances. So in terms of what we received out of that process from industry, it was difficult to come up with a comprehensive analysis, but we used the data from the analysis done through the SOCI Act, which has the same obligations, to help inform our view.
Well, that sort of opens the door to the duplication issue, doesn't it? A number of stakeholders raised complaints this morning and in their submissions about the duplication of particularly particularly around all hazards. What do you have to say about that?
So, Deputy Chair, and listening very intently this morning to the participants and some of the things, and I think there were some of the issues that were raised was duplication, or that there was already existing arrangements across a few different frameworks.
Yeah.
So I might just break that down a little bit. So there was raised about duplication under the SOCI Act, so that there are currently a number of airports and the airlines who sit within SOCI as well. Not all airports sit within, are regulated or fall under the SOCI Act. Same with maritime ports. There are 20 ports that meet the definition of critical ports, and so therefore are under SOCI Act as well. So there is at the moment a differential between the broader industry in aviation, transport, security and maritime and offshore facilities, and then regulation of SOCI. The intention is, and what we have worked with industry to try to ensure that they understand, is that there are currently obligations under SOCI for reporting of cyber incidents. Those, once that is available under this legislation, those obligations under SOCI won't be utilised under that Act for those participants.
Won't be required.
Won't be required under SOCI. The reporting, the obligations will fall under ATSA and MTOFSA, so to reduce any confusion around the reporting requirements for that particular Act. The other issue that I had raised was regarding particularly around the natural hazards, and that actually exists under the safety framework. And whilst that is true, that there are aspects under the safety framework, regulatory framework, that require a natural hazards consideration, those considerations do relate, as they should, to safety, and don't really reflect the nature of the way that we would like to have security considered for natural hazards. One of the things that was, one of the recommendations from the Heartland Review was to consider the way that SOCI formulated an all hazards approach as a more robust and more holistic consideration of the security requirements, and that is what we're trying to achieve by considering the all hazards approach in this package.
I asked the question of the airlines whether the all hazards approach that you want to introduce here is being done anywhere else in the world, and the response was not in countries in which they're operating. Not that I have any objection to Australia being world-beating or world-leading in certain circumstances, if it's appropriate, but is this first-of-type legislation in the world?
It does sound a little disingenuous to pat ourselves on the back to say that we're world-leading. So I would say that yes, we have considered our partners and asked them about what they're doing. To be fair, while they are not currently implemented, we know that there are efforts underway to consider introducing this all hazards approach across, and I think you particularly mentioned Canada. We've worked quite closely with Canada. They do have a slightly more layered approach. They consider critical infrastructure, which includes transport, and are looking to introduce an all hazards approach within their framework for critical infrastructure. There are also considerations under their transport security, equivalent transport security legislation to introduce a broader frame around all hazards as well. So whilst we may be forward-leaning in where we are in the cycle, I think that we certainly have evidence that our partners are considering that. I'd also just turn to Mr Pedler to mention recent considerations that in Oman as part of
Thank you. We heard testimony this morning about Annex 17 and a sort of inconsistency with Annex 17 with our approach. Annex 17 deals with security. It is true that at the moment there is no language around natural hazards or all hazards in that document. However, there are many discussions taking place in the ICAO under the Annex 17 framework around this. Annex 17 is not a static document. It's a living document, and in fact ICAO in December last year there was a security forum in Muscat, Oman, where ICAO made a declaration, and if I can just read a small part of that, which acknowledging the importance of a common UN approach involving cooperation and coordination among all relevant UN bodies and specialised agencies in recognising the aviation sector as critical infrastructure on which national security, prosperity and development, as well as the global economy, are dependent. So certainly taking the critical infrastructure approach in which we are mirroring the obligations from the Security of Critical Infrastructure Act and putting them into the transport security legislation, the ATSA and MATOFSA, is certainly consistent with the way that many discussions are taking place around the world.
Can I take you to the 10C authorised access issue? You may have heard me speak to the ports people earlier before. Is there any recourse or cost recovery mechanisms for businesses that are impacted by authorised actions?
Deputy Chair, no, there are not. As the Ports Australia representative indicated, the MATOFSA is not the appropriate avenue to pursue that type of action.
In relation to compliance statements, can you confirm whether organisations must update their maritime safety plans immediately post legislation, or can they wait until renewal?
The intention is that we are not requesting updates for the maritime security plans. They will need to be considered, and they would be done over a period of time, which is why we have a sort of period for introduction of the processes as we do them. The intent is not to require an immediate change to maritime security plans post introduction of the passage of the
What sort of timeframes do you envisage them having to be able to do that?
I think that would it's the next. It would be at the next update. Although
on renewal.
On renewal.
Yeah.
Sorry, I just wanted to say that I think that depends also on the maritime security plan. There's an option for industry participants to amend before their renewal as well. So if they chose to, so I don't want to say that they must wait either.
No, sure, yeah. but there would be a maximum time frame at renewal. Does the proposed definition of ports have any differentiation between industrial and recreational ports, such as cruise terminals?
I'll ask Ms Fox. The proposed definition of ports, no, we're not sort of differentiating, but if it's a security regulated port, we don't differentiate between it, and some ports are security.
Sorry, go on.
Some ports they might have a cruise terminal as part of their security regulated port. Others that might those recreational facilities might not be part of it. So every port is different.
Every port is different. Could this have an impact on the tourism sector for, say, cruise terminals?
I wouldn't see why.
If you're unable to, if your answer is every port is different, every port would be considered on its own merits. Is that what you're saying?
Yes. So every port, in redefining the port boundary, will be considered on a case-by-case basis in consultation with that port.
So it's possible that cruise terminal ports could be captured by the legislation. That would have an impact on tourism costs, wouldn't it?
Yes, but those ports are already captured. So a cruise terminal already has some obligations. The changing of the definition of a port, I don't see how it would in particular impact a cruise ship.
The scope, the amendment doesn't bring into scope additional cruise ports that would be impacted by additional cruise ships.
Are you satisfied with the clarity of the definition of ports?
I think we've recognised that it is a real challenge, as Mr Gallagher and Mr Tierney said this morning. It has been a concern, and it's something we've recognised with industry, and we're very keen to continue to work with industry. Ports have evolved over time. They're very complex in their nature, as described, the participants and the diverse nature of the various elements of what's required to operate with a port and those complexities. So we have very much recognised that is a complex issue, and wish to continue to work with industry to refine and continue to think about how we can make those definitions clearer and more workable, and to improve our understanding of ports.
How do we do that? Is that in what environment is that done in? I'm just concerned that the regular or the department is acknowledging that there's a degree of lack of specificity in the definition, and yet we're being asked to make recommendations to the Parliament that the bill should proceed to being passed, and yet you're here saying we accept that this is a problem.
We accept that there is a requirement to continue to engage with industry, and I think based on, and I don't want to, verbal Mr Gallagher or Mr Tierney from this morning, they were very clear though that they believe that we've recognised the concern, that we are very alive to it, that we're working with them. I think the way that we have put it within the proposed legislation is to provide some scope for us to then continue to work with them through the regulatory process, the development of regs process, but also our ongoing industry engagement. We work very closely with the maritime and the aviation sectors. We have regular ongoing engagement and consultative forums that we work with them on these issues to try and resolve. We are also doing some extended research work that we're looking to understand the criticality of ports, and that to add to our understanding of the nature of ports as they are in this modern environment.
Thank you.
All right, I'm going to hand over the call now to Ms Swanson.
Thanks, Chair, and thanks, Ms Pfeiffer. Look, some industry have shared frustrations. You've sat in the room and heard those frustrations, and I couch this question with, we're living in an ever evolving, rapidly changing security threat world, a quickening of tempo. I think that obviously industry representatives from the aviation sector recognised that in their statements this morning. So the bill proposes expanded definitions and security requirements and things that, you know, are going to need to be changed. So we can't change the consultation, and we've heard a graduated response, I would say, from 8 out of 10 from the ports for your engagement to whilst the aviation sector didn't give the department a score, I would hazard a guess to say that it was not 8. It was less than that. So what I'm really interested in, if this bill is to pass, it seems to me that the regulations are really the critical point. How does the department intend to really meaningfully consult, co-design going forward? What's the time frame with industry on the regulations? For me, that's where the rubber hits the road on this bill. You know, if we're going to recommend that it be passed and that it should go ahead, how are you going to? Because this is critical. I mean, as Australians,
Absolutely.
we've all got to work together. We keep saying that, but yet we get people in a room and they say, well, look, we just don't feel as though we've been consulted with properly. The time frame's been compressed. You feel as though you've done a good job of it. So, you know, you sat in the room this morning, you heard the evidence. So moving forward, how do we make this right? How do we make it better so that, you know, people in the aviation sector can say, well, yeah, you know, we feel as though things have improved. How do we write these regulations? What do we do? What's the time frame moving forward?
So we're very keen to continue what we consider quite an extensive consultation and framework that we work with the industry participants across maritime and aviation. We, as I just mentioned, we have groups. Obviously, the aviation cargo sector is different to the aviation airline sector, so there are complexities in this environment. We do consultation with them as a whole and as a town hall style engagements where we try and seek views, broad views, and have also conducted consultation at more granular level by splitting the groups into various sectors to get a narrower view, a more deep dive into particular concerns of the subsectors within the aviation sector as well as the maritime sector. So we continue to do that and will continue to do that. Our next steps are very much that we are ready, subject to the passage of the bill, to engage very deeply on the regulations and the next process for consultation with that. What we would like to do is to work with the sector at large, because there are interplays between those segments within the sector, so we don't want to lose that view, but then deep dive within regarding the specific nature of the impacts for each sort of segment within the broader sector. That is the process that we're planning on right now. So the team are already developing that framework in the event of the passage of the bill, and would be keen to engage with industry as soon as we start. What we would do is we don't want to preempt anything by presenting here we've drafted something. What we've done is prepared our thoughts around the way that the regulatory framework would operate, what we see the impacts might be, and then what we want to do is work with industry to present those and then get their feedback and their understanding of what that might mean in practice as they operationalise those intents that we are looking to present to them. I think this needs to be an iterative process. We can't expect that we're just going to get it right the first go, and we definitely don't want to do that, because it means that we need. It means that we're not working closely enough with industry if we are doing that. Very much, we would like to take the opportunity, as I said, to work in an iterative way that allows for us to present options, ideas, get that feedback, have industry have some time to consider their views, then bring that back to us and work through that in workshop-style approaches.
And are there any urgent security gaps that are going to be met by the passing of this bill? You know, what are the big ones?
We have great concern regarding the threat of cyber. Cybersecurity is of great concern to us, and having heard your questioning earlier, I think we're all very alive to the fact that our acts have not been substantially changed for a very long period of time. So it really doesn't conceive beyond the initial threat of terrorism the types of things that we are now seeing in that threat environment. Cyber threat, to be honest, in addition to cyber threat, insider threat, risks involved, foreign interference threats, those sorts of issues were really not forefront of the way that the legislation was framed up. All of those are in a completely different situation now, and the Director General ASIO's presentation last night certainly narrowed focus around the impact of those risks and threats to critical infrastructure in particular. And for us, the aviation and maritime sector are the backbone, really, of our critical infrastructure. They're so fundamental to our way of life, our economy, and our supply chains. They are actually incredibly fundamental to all of that. As an island nation particularly, the maritime cargo issue is really important to us. And Mr Tierney mentioned the impact of their incident, and that on a more national scale would be something we would never want to conceive of. Currently, our legislation does not have provisions around cyber security. We have worked very closely with industry and asked them to look at this risk, and we believe that most industry participants have taken that completely on board, and even our friends at Qantas, we're very aware of the efforts that they've gone to do that, but it's not sitting within our framework at the moment, and that for me is the real gap in our current framework. In addition, I think the other threats around insider threat and some of those other things can't be underestimated as we move forward.
And just on that, in relation to some of the Commonwealth agencies that stakeholders have identified that they already report to, so they report to CASA, they report to the Australian Transport Safety Bureau, the Bureau of Meteorology. The bill requires them to report to both Home Affairs and ASD, ASD particularly withstanding cyber and the increased threat that poses. But what are we doing to streamline some of that reporting? Because look, I am hearing, and I do understand that we're in an incredibly delicate balance here between a requirement to report so that people at ASD get the frontline information, yet we do have organisations that are often saying that they're tied up in red tape, so we've got to have a balance. So in terms of streamlining, what's your thinking on that at this point?
So under the Cybersecurity Strategy 2023 to 2030, there is a measure in there that is actually looking to facilitate or create a single reporting portal for incidents.
Yes, I've got that to ask you. How's that going?
Yes,
yeah.
So that work is being progressed at the moment to avoid the duplicative reporting process, and that is something that my colleague, Mr Anstey, it sits within his portfolio of responsibilities, and he has been, I know it's certainly front and centre of the activities that we are looking to progress in that cyber security space, and it's really critical that we have that because we don't want people to be focusing on reporting or multiple reporting regimes when they need to be dealing with a crisis. So it's certainly something that we want to do. The point of the portal is to simply have a single point of reporting, and then all of the agencies who need to have access to that information will be able to draw forward the information they need for their specific purposes.
And just two more, if I may, Chair, just on this same thread of thought. Harmonisation with state and territory-based reporting requirements, has that been considered as well?
Absolutely. work very closely with our state and territory counterparts. Something that we do in our critical infrastructure framework is we have our what we call SIAC, so the Critical Infrastructure Advisory Council, which has representatives from our critical infrastructure network. Our Trusted Information Sharing Network is our network of critical infrastructure industry representatives. The SIAC includes representatives of state and territory governments with a view that we are trying to then harmonise or bring together a conversation about the requirements layered across government and industry. It also includes representatives from Commonwealth agencies who regulate the various entities as well.
And I suppose going the other way, going sort of downstream to state and territories, Mr Gallagher mentioned the international window, a maritime single window. Can you speak to that and how that will intersect? I suppose it follows on from the Deputy Chair's comments about Canadian experience and you know, us being world leaders. But so how does that intersect with this bill and what will that mean for... I know it's maritime, but...
No. Happy to discuss. So I think there's the two acts that we have. So ATSA, which is aviation, maritime, MATOFSA, maritime and offshore facilities. One of the reasons that we have those acts and that we have considered and retained them as separate acts rather than, I suppose, there would be an argument to merge them in with critical infrastructure areas because both of these industries have there are international frameworks and international obligations which we take very, very seriously. Mr Pedler mentioned our ICAO, which is the aviation. There are similar sort of international organisations around the maritime framework as well that mean that we need to meet and continue to meet those international obligations. Separate to that, we have relationships with our partners globally, many nations, to work on consistency because these are global systems that we need to work within that framework. So there are clearly those obligations that we have under those oversight bodies formulated under the UN, but then there are our international relationships which allow us to work with our partners, learn from them, see what they're doing, see what can work in our context as well and be able to draw that together. One of the things that we do is seek for opportunities for international partners to come and present to our industry reps about what they're doing, what they're seeing, so that we can expand their threat and understanding. Ms Fox, have you got anything to add on the window?
Sure. So the maritime single window is a platform for industry to provide regulatory information regarding the arrival and departure of ships into ports. So it's very separate to cybersecurity reporting and separate to the portal that we're proposing. But I guess just another example of trying to find an efficient way for our industry sectors to adhere to their regulatory requirements.
I mean, surely technology is our friend in this regard. I mean, we've got incoming cyber attacks and that poses all kinds of threats and difficulties. But on the other side of that coin, we've got technology. I mean, I can go on my phone and tell you where every ship is currently in the world. I think that's remarkable and I quite enjoy it. But, so are we embracing that as well,
Absolutely. We are looking to find ways to streamline and to bring industry, to bring us into the way that we can operate to make it as efficient and as effective as possible for industry to comply with regulatory requirements. Absolutely. We also need to make sure that those systems are safe, secure, robust, meet the requirements of us and industry, and make sure that we aren't creating potential problems by bringing things together in a way that maybe isn't secure. But we're certainly working on that, and that's a big priority for us.
Sorry, Chair, just one. So should the committee wish to recommend the passing of this bill, do we have the department's word that you are going to genuinely and in good faith, continue your interaction with particularly the aviation industry and other stakeholders? Because you sat in the room this morning, they're clearly unhappy and we need to sort it.
Absolutely. Absolutely.
Thank you.
Thanks for that, Ms. Swanson. Just following up from that, I was just hoping from an early question, I think Mr. Wallace may have asked, but hoping that you might be able to talk through the consultation process. And in light of what Ms. Swanson said, any further opportunities from post today about dealing and engaging with the industry, because we've heard obviously quite a large number of evidence before us, and just want to make sure that there is a clear understanding that the industry is still able to consult or at least engage with the department on this issue.
Absolutely, and our door is always open for industry if they feel that they want to raise issues with us. I'm more than happy to hear from them. I will start in terms of a consideration of our consultation process. Following the reporting of the independent review, and we had a discussion paper responding to the independent review as well. There were 12 incidents of engagement, including town halls, roundtables, a public town hall that was open to a very broad range of stakeholders, even outside our normal industry perspective, industry players. As I said before, we broke that down, some of that consultation down by segment, because we want to give an opportunity for particular sectors to be able to provide input into. So air cargo, regional aviation, aviation more broadly, maritime separate. So there were 2 rounds of sort of round table conversations, one in May, one in April, and that was to allow industry the opportunity to consider what was put forward as part of those conversations and then come back to us with further questions. So those were conducted, like I said, between 10th of May and the 4th of April. We also consulted regarding the specific consultation on the drafting measures, the measures that we had considered and our early assessments. We conducted a further 11 town halls, roundtables and impact analysis costing sessions, again broad groups and then more detailed groups including aviation, air cargo and maritime, to make sure that there was opportunity for sector-specific nuanced conversations. In addition to those, we also held Transport Security Reforms Town Hall. One was held on the 13th of November. That was a very broad group that allowed as I said, not just the usual players that we engage with. We have obviously sector groups that we work with on a very regular basis. We also conducted a town hall on the 21st of October specifically to address the first pass impact analysis and provide opportunities for further discussion on that. We also have a transport security industry advisory committee that we stood up. There were 2 meetings for that group on the 30th of May and the 17th of July. Those are a cross-sector group that we have drawn together for those discussions. And as I said, in terms then of those are opportunities for forums. In addition to those, we actually have a series of engagements across the sectors which include the maritime, I'm going to get the name wrong so I might ask Ms Fox to correct me, Maritime Industry Consultative Security Forum, which is our maritime group, which is representatives from ports and port operators across Australia that meets on a regular basis at least 3 times a year. Normally at least one of those is a face-to-face meeting and the others are normally virtual to allow optimal participation in that process. And then we also have within the aviation sector a group specifically for regional aviation participants, as well as an air cargo forum, and also includes consignors and air cargo operators that are outside the airports, as well as a forum for a broader aviation security forum. Those meetings, again, similar to the MISCF, occur with each of those groups around 3 times a year, just depending on availability and criticality. Again, we operate those as in person as well as virtual to maximise opportunity, particularly for regional airports that may struggle to be able to come to events on a regular basis, to maximise participation opportunities for engagement. At those forums, we have discussed the broad, the framework and the proposal on the way forward from the independent review and what we were proposing at each of those meetings over the last, 18 months. Sorry.
Because I mean, a number of submitters have expressed, I guess, concern about maybe the perception of the department's adopting a more punitive approach as a regulator, and I was just wanted to see if there'd been any effort to talk to them about the importance also having a much more educative approach. And I'm glad you picked up the small airports, because I think there was greater concern from those entities, organisations, around how the department might be perceived in terms of its approach towards airports.
Certainly, smaller airports are a concern for us, and we go to great efforts to work particularly with regional airports. As Mr Pedler sort of mentioned before, the very small airports are not regulated entities for us. So whilst we still may engage and make them aware of the activities that we're doing, they're not regulated entities. It's only once we get into the tiers of the size of the airports that we work with. We're very open to working with industry, particularly all of our industry participants, to make sure that they feel comfortable and understand. The point of our regulatory, the way that we work within our regulatory framework is a framework that clearly has harsher measures or firmer measures that we would use in the instances where we see non-compliance that is something that we feel can't be rectified or we can't work with. However, we work in a very collaborative manner with industry and with individual players when we see areas of concern to try and mitigate and change those behaviours or those concerns, those issues that we might see arising, and work within a continuum of looking to inform, make sure people are aware, excuse me, of their regulatory requirements, education, then moving towards more firmer measures, depending on if we are not being able to see the amendments and the change in the way that we want to see industry.
So what's your assessment if change does not occur? The impact that will have, the threat levels that will have on the sector or the economy?
With the change with the Act?
Yeah.
I think there are real exposures and gaps that would make it very difficult for us to manage the type of significant cyber incidents or the significant type of living off the land type activity we've seen with things like Volt Typhoon that we know have occurred in other countries, particularly the US. We've seen reporting regarding those things. We really, this Act and the way the amendments that we're proposing are there to help us to work with industry to really understand what those threats are and the impacts and the flow-on impacts from those. And I think Mr Gallagher, in his discussion this morning, mentioned supply chain and those concerns. For us, critical infrastructure and transport, this transport sector in particular, are so intertwined and so codependent. The aggregate risk that we see across those critical infrastructure, it's really important for us that we have a baseline understanding and a baseline that we can work with industry about what we need to do to protect our critical infrastructure.
All right, thank you. Yeah, I think Ms Mackenzie had
She's ducked out, but I do know the question she was going to ask.
If you could ask the question on her behalf.
Thank you.
And then we'll wrap up. Thank you.
Thanks, Chair.
Deputy Chair.
Just in relation to the cyber and national security risk profiles, does the department consider a longer transition period than 12 months could be feasible, particularly for regional and small airport operators?
I think we did mention earlier, Deputy Chair, regarding the scale and the way that impacts, and I think if your interest is particularly for the smaller and regional airports, the cyber security provisions are not looking to be applied to those smaller airports. Is that your particular concern?
Yeah. Looking at the implementation timeframes.
Yeah. So, look, I'd be happy if
Deputy Chair, if I can just paraphrase you there, I think the AAA said this morning that they were hoping for it to be extended to 24 months rather than 12 months. That was their ask. Yeah.
So thanks, Meryl. Is that something that you would consider as appropriate?
I think that's something we could take under consideration and discuss with government and consider that.
Ms McKenzie?
And just to that end, it was on the same point. So I have a small airfield in my electorate. I assume that airfields that aren't currently regulated by CASA are beyond the remit of this.
If they're not currently our regulated entities, which I can't imagine that would be, they would not be impacted by this.
So even though they're part of the ecosystem and or the supply chain sometimes, not.
They're not current.
All right, well, thanks everyone. Thank you to the department. Thanks to the committee members. There have been no other witnesses today. I happy to declare that this public hearing will close. But before I say, just thank you to the department. The Secretary will also be in touch with you if there were any questions taken on notice, and also provide a copy of today's transcript. Okay, well, thanks everyone. On that note, the committee now stands adjourned and will close at 11:45. Thank you.
you.